15 days.
15 days.
Highly obliging. Highly obliging.
Not children 2011.
Okay. Appreciated, sir. My lord, in the first FIR, my lord.
Why are you apprehending? First tell us.
My lord, in the second FIR has been lost by the father of the thief. In the second FIR, my lord, my name has been.
What is that?
Page, my lord, 18, my lord. And my lord, I am the, my lord, reporter. And I publish the genuine news, my lord.
Don't-
That's why my name has been.
Don't say reporter. We have seen last 2-3 days.
My lord, my humble submission, my lord. My lord, subsequently, 2 persons are mentioned, my lord. My lord, and 2 persons has been enlarged on bail by this honorable.
What is the true news you have published that for the
My
reason?
lord, actually, my lord, the victim who is a major girl, he fled away with one person, my lord.
Hmm.
And thereafter, that lady,
Somebody eloped with someone. What is your business?
my lord,
Is it a news?
my lord, may I submit, my lord?
Huh? Yes.
Then, my lord, what happened, my lord? The girl,
You will enter into people's bedroom. Huh?
no, my lord.
You will do who has eloped with whom.
No, my lord, that is
You have
not,
no other job.
no, that is not allegation.
No, we know that is not the allegation. But what is the allegation? That's why you have been alleged.
My lord, only, my lord, I advised the main accused, my lord. That is the allegation. And
What have you advised?
my lord, you lordship kindly see, by page 19, my lord. After getting such ill advice from accused number 1 and 2, the other accused person forcibly hit her poison mixed with the milk. My lord, that is the my
City interim.
obligation.
On 2111.
On after 10 days, within 10 days, I will
Within
accept.
10.
Obligation. Yeah,
City interim.
much obliged.
Date 2111.
Much obliged. May I in the petition for transfer the TV case, maintenance case.
Only notice with a cost to be deposited so that the wife can engage account.
And
That much.
previously,
Forget about any interim one. Tell us how much cost for the girl to come to engage a lawyer.
in the previous litigation round of litigation, he has already engaged lawyers in Guwahati. When we have filed a divorce case previously, she challenged it for transferring, and this honorable court rejected her prayer and directed her to appear before the family court here. And accordingly, the family court also directed us to pay her the cost of traveling, and we are paying that cost, my lord.
Any order passed in 125?
No,
Then
so far, one appearance is on. We have
so therefore give us a cost
the material
20,000.
and not even the petitioner can
Only
afford-
for notice 10,000, notice and stay 20,000.
my lord,
Have instruction and
Mine.
come back.
Mine.
Day after tomorrow.
But if the matter may be passable.
What is this?
Not if my senior counsel is not feeling well.
Not feeling well, so we'll take after vacation. Let him feel well.
No.
Okay? Please after vacation. On the prayer of the learned. Okay, we shall repeat. None appears for the petitioner on call. None did represent the petitioner on call when the matter was listed on 16/8/2023 and 29/2023. The Honorable Apex Court in a recent judgment in so and so has provided that even the criminal petition can be determined in absence of the petitioner or his counsel on merit. The present application is filed under section 482 of the Code of Criminal Procedure 1973 for quashing CR case number 161/2022 under section 7 of the Essential Commodities Act 1955. And also with a further prayer to quash the offense report dated 2020. First up, peruse the FIR as well as the offense report, which are to the following effect. Page 11. Reading of the FIR and the offense report as a whole, if are taken to be true, as a whole taken to be true, prima facie case under section 7 is made out. In view of that, this court is not inclined to interfere with the CR case. Accordingly, the same stands dismissed.
All right.
That's your hard paid.
May I please the lordship?
Yes,
Lordship, I beg, kindly pass over the matter for the day, lordship, as my senior IROP is out of state.
your
Yeah.
hard MSA
Afrin.
Afrin, Learned Counsel for the petitioner. I wrote it first. The present IA is filed for implement of informant as respondent in the connected criminal petition being criminal petition number 966/2023. 2023. Full stop. This court, under its order dated 14/9/2023, directed the petitioner to file to implead the informant as the respondent in the aforesaid criminal petition number 96 of 2023. Accordingly, the present application is filed. Full stop. Peruse the material. Peruse the material available on record. Also consider the order dated 14/9/2023 passed by this court in criminal petition number 966/2023. Full stop. Considering the material. Who is the informant? Not a single whisper in the IA. Who is the informant? Now we'll have to verify from the
Basir Ali.
accordingly. The informant, namely, IA profile, very profile.
Page 12.
Page 12. Be implemented as respondent number 2 in criminal petition number 966 of 2023. Registry to do the needful for correction of the cost title in criminal petition number 966 of 2023. With the aforesaid direction, the IA stands closed. Yes, next. Yes.
Ma'am,
Yes.
for it application, NBT PN is issued, my lord.
Appear, we are suspending.
My lord.
You appear before the court.
Yes, my lord.
Will suspend till appearance and filing of application.
My lord, here it, one thing is there, in 30, the IU has annexed one birth certificate, where is and the date of birth 152 mentioned. But as per the birth certificate, the age is 18 years, 6 months and 4 days.
That we understand, but what is your prayer in this case?
Ma-
What is that we understand? Because it was, POXO was not even, Sarsit, there is no POXO. Is not it?
Yes.
But the learned court took cognizance, you have not challenged that order.
we may allow to go.
This court also, this court also considers that the investigating officer, while filing the search sheet, has not laid any search against the petitioner under any provision of the POXO Act. Isn't it? What is the search sheet?
Certificate page number. Annexure 2, page number 28.
Huh?
Annexure 2, page number 28, particular, my lord. Particular, 28.
No. There was an order. Let us see the order.
Order is page 41. 41.
Do not remember so many cases. Na? You get confused sometimes.
Lord.
Page 41. Okay, don't appear before the court and seek for
Obvious, ma'am.
the learned counsel further considers that the minor further submits that further submits that the girl is not a minor and her birth certificate itself shows that she was more than 18 years on the date of commission of the offense. Full stop. Without commenting on merit of such submission, it is provided that the learned trial court may consider all the aforesaid contentions of the learned counsel for the petitioner while considering it.
Obvious, ma'am.
আমি যেটা divided till then.
Till appearance.
Yes, Talukdar, why should we?
Court issue application last time.
Huh? Why
Son-in-law
should we?
filing against the father-in-law.
SEC is
Because
there.
from documents we can show the daughter has paid everything. So there is no question of any liability, enforceable legal debt is there.
That can be a defense in the trial.
No, there can be a difference, but at least it is apparent, because that is their document. He has annexed that along with the complaint. And land was for 14,50,000 and he has taken check of 30,000.
Yes,
30
we have
lakhs.
seen everything.
That's why at this stage.
But only question is that
When it is
that can
apparent,
be a defense.
that is all right. For rebuttal it
Because-
is there,
Because presumption is against you. There was a SEC was bounced.
but that was stop payment was made. That is there. Another thing is there. Because the moment bank called me, I have asked them to stop payment because those checks were lying in my daughter's house. She came back to me.
Now,
So he has used.
decide all this here.
No, that can be because apparent. It is apparent from the face of it that 14,50,000 is the amount.
Yeah, because only
And
six,
how 30
only
lakhs will
6 days are there. Hard,
come?
Mr. Talukdar, learned counsel for the petitioner. Also, Mr. Goswami, learned.
That's one number 2.
Number 2. The present application is filed under section 482 of the Code of Criminal Procedure 1973 for quashing the complaint case being CR case number 1364/2023, which is now pending before the learned judicial magistrate first class Kamrup Metro at Guwahati. Referring to certain documents, Mr. Talukdar submits that it is apparent on the face of the record that there is no liability so far relating to the present petitioner, inasmuch as the present petitioner and the complainant, that the complainant is the son-in-law of the present petitioner, and specifically has been taken that there is no similarity between the claim on the basis of which it is alleged that there is a enforceable liability
Of 30 lakh.
of 30 lakhs, inasmuch as the land in question for which it was alleged that money was paid is of
Of 14 lakhs 50,000.
of 14 lakhs 50,000. Full stop. The further contention raised is that already there is a case pending under section case pending
406.
under section 406 filed by the daughter of the present petitioner, and out of such dispute, the check pending, the signed check which was with the daughter of the present petitioner, the complainant has misused it and filed a false case. Full stop. This matter needs further consideration. Accordingly, issue notice returnable after 6 weeks. So and so accept notice. For others within 5 days, returnable 6 weeks after 5 days. Till such return of notice. Further proceeding of CR case
CR
number
One
so and so pending before
one three six
so
four
and so
oblique 23.
shall remain suspended.
Much.
Sanction.
No.
Now tell us two things.
No.
Sanction is necessary.
No.
From whom?
From your lordship, the central government as well as the state government.
Central government as well as state government.
State.
Both sanctions are required.
No.
Now, earlier, the so far relating to the UAPA, there were judgments following American jurisprudence of liberty. It was felt that only being a part of a unlawful organization, you cannot be termed as an accused until and unless some overt acts are given.
That has been
That case was overruled
Over-
in a review case.
Lord.
And one of the reasons for such review was that central government was not a part.
Lord.
Is that it?
Lord.
Here also central government is not
So
a
your
part.
lordship, we are not concerned with the any action taken by the central government.
But sanction is from who?
But your lordship, it is not the issue of sanction by the central government. Our main grievance is that the court can take cognizance, your lordship, without sanction.
No, that we understand.
Lord.
Sanction from whom?
Sanction from the state government as well as the central
So
government.
therefore, what is the problem in incorporating central government?
We can, your lordship.
Is,
but
I think according to this code, it is necessary.
no, we will do it, your lordship. We'll do it. That's
You do it. We are issuing notice and now at what at
evidence will be.
we'll
started.
stay it. We'll
Lord.
stay the proceeding.
Lord.
That is not a problem
Lord.
because if you can show sanction is not there, before passing an order, we need to hear the central government.
We will make central government a part.
You make a central government a party, we are permitting it today. We list it on Monday.
Lord.
Okay. And now the procedure is different. You will have to
Well,
go
I
and
know
give
you.
the cost title.
Lord.
According to me, since they are represented, okay, state government.
Lord.
Even, in fact, home department is necessary.
Lord.
But even then, if no sanction is there, they will examine it.
Lord.
No question of that. But according to this court, that is necessary.
Lord.
That defect should not remain. Mr. Borthaku, learned counsel for the petitioner, is permitted to add the Ministry of Home Affairs.
Lord.
Ministry of Home Affairs, Union of India, as party respondent in the present case,
Also the state government.
and also the state government in Home Department. Full stop. Today is the same be done as per the same be the cost title be corrected in terms of the extent norms. Extent norms of the register.
Sure.
After such correction, list this matter on Monday.
Sure.
16th. In the meantime, copy of the application petition be furnished to the respective councils of Union of India as well as
State.
the state, the senior government advocate, state of Assam. That marks today.
Sure.
List this matter on.
Sixteen.
Obliged.
I think this is necessary. So that later on they will come and say that we are the sanctioning authority, we are not being heard.
Obliged.
Yes, please. Yes, ma'am. Expected me to withdraw this bill.
Huh?
It's my expected me to withdraw this bill.
Bail,
Please no withdraw.
withdrawal. You want to withdraw this?
But-
Withdraw whatever you want to withdraw now. Yes. Withdraw.
Obliged. In this case, your lordship, charges has been filed and he is more than 150 days in custody.
What is the allegation?
Allegation in order under section 366 and 371. Partly her examination was also PW1, victim girl has been partly examined.
What is the victim girl's examination?
This is a certified copy.
What partly examined?
Then further cross examination is actually from one side. So from my accused, partly cross examination. Both the accused person are known to her.
Pramal Protim Laskar.
Yes, your lordship. Both the accused person are known to him and they reside in the same campus.
Just a minute, just. What is the 164 statement?
One institution actually record has been called for, can copy.
Gorua, go to it. We'll take it up on Monday.
No, your lordship, last day actually copy received. They have taken time that we will require time for furnishing.
Maybe
Yeah,
today
it is
after some
150
time.
days.
I'll go through. After some time.
To
I'll
go
go
through. She had a relation, that live streaming.
is incomplete one based on totally incomplete investigation.
Hmm.
And Lordship will find the FIR at page number 15, Annexure 1, type 10 translate copy. 15. Lord.
Yes.
There are 8 number of accused persons named in the FIR. And my name is Lordship will find at page number 16. at serial number 8.
Rizaul Islam.
Riazul Islam.
What is the allegation?
Allegation is that the accused person entered the house of the informant, that is one Amina Khatun. Lordship, thereafter, Lordship assaulted the elder son of the Lordship informant, Asghar Ali, and causing
It's
serious
CBI,
injury.
CBI case.
Lordship,
Why CBI?
Initially, it has been investigated by Assam police and subsequently it has been given to
CBI.
CBI. Lordship.
Oh,
By
that case.
Good morning, Rabha.
By
John Monira.
Prime-
This is the offspring of John Monira, not the John Monira.
No, yes,
the prime accused is that
this is the first case.
SI Lordship.
First case. No,
Now
no,
he is inside.
he is
I'm
inside.
inside.
What is your case? What is your case?
My case is that the Tarsik profile is the incomplete one, and based on totally incomplete investigation. Only to defeat my right of default Lordship. They filed the incomplete charge.
Hmm.
That I will satisfy Lordship from the Lordship.
Assuming that it is an incomplete certificate. What is the law? Let us assume it. It is an incomplete certificate.
But law is that Lordship investigation has to be done as a whole. Lordship. It cannot be said that Lordship
No
Uh,
part search.
no part charge sheet. It cannot be said that Lordship out of 10 accused persons, 4 accused persons have been charged with it, and the further investigation is will continue with
Why do
regard
you
to
need him?
Lordship, he is the main accused who has received the amount. Dunmoni Rabha, along with the other accomplice, they entered into the house of the informant.
They file charge sheet. Why you
He has
need
filed
him?
the-
You are a mighty police, CID. Can he influence him?
No,
Why do you need
Yes,
his?
Lordship, there's every possibility of pleading away from the justice, Lordship. Because cross cases are pending, Lordship. There are 2 more cases regarding the murder, I mean to say the suspicious death of the IO.
the Lordship.
Obviously, Dunmoni Rabha, he has been,
Lordship
that is the,
charge sheet is
difficult.
filed under 395 Lordship, only session tribal case, only non-variable section. And Lordship will find Lordship there from their language Lordship. Lordship will may come to charge sheet Lordship, where Annexure 7, page number 36.
You do one thing. Wait for some time. Wait for some time. Let us finish all these bills. We'll go through it. Other bail, normal bail petitions.
Lord.
Let us complete it.
Please do your
Yes.
Your Lordship, charge sheet has been submitted in the lower court, and final report has been filed against the parent.
Is it? Where is that?
My lord, that is, my lord, we have not received any instruction.
We'll say we'll close it. So there is nothing survives in this petition.
Yes, Your Lordship. And moreover, the prime accused has been granted bail by the honorable court.
No, that is not the look. You can have to either of the submission on merit, or you say that it is charge sheet file, and I have not sent for trial. We'll record it and close it. That's all. The learned counsel for the petitioner submits that submits that the investigating officer has already filed charge sheet in Nalbari PS case number 237/2023 under section 302/34 of IPC. However, the present petitioner has not been sent for trial. Accordingly, nothing survives in this petition to be adjudicated. In that view of the matter, the present application stands closed. Interim order, if any, stands vacant.
We have not received any information.
Okay, that is just his risk. Suppose he is not sent. That is his submission. So we close it.
Yes, pleasure, Lordship.
Yes.
Lordship, this is 438 bail application.
Hmm.
Case that is not received.
Is not received.
Lordship,
They are on interim note.
yes, interim.
They are interim.
Yes.
Okay, fine.
2311.
2311 interim to continue.
Yep, yep.
Yes,
438 application, my lord. I am on interim, my lord. And I am a
Case that is
recipient, of-
received.
I am recipient of stolen goods. Admitted,
Admitted.
admitted.
What is the stolen goods?
My lord, petal nut.
Beetle. And what is this? What is in the city?
There are my lord materials already collected by the IO lordship. And secondly, lordship, most important thing is that after my lord granting interim protection from his honorable court, he has not cooperated. He has not given any details, my lord, before he has appeared before the IO lordship, statement recorded, but he has not cooperated with the investigation.
What kind of cooperation?
Cooperation, Lordship, he has not said anything, Lordship.
If nothing is to be, that cannot be said to be cooperation.
No,
If
no,
he has gone,
that is the
he
objection.
have
of the IO.
given, no, that objection we understand.
Yes.
Suppose he is a receiving of a stolen coupon. Court protected him. He went there and gave his statement that this, that.
He only said, I
Can
do
you
not know
com-
anything.
huh?
He said, I do not know anything, and still Lordship, 100 bags of copper is yet to be recovered. If he is not cooperative to investigate, he should say, Lordship, I have told it, or I have told
You
it.
want to have his statement once again. You have it. You will have it, we'll provide that. Yes, Doctor, go and appear, we are extending the interim order.
And one more thing, my lord, in the FIR itself said, my lord, later on, my lord, police recovered the stolen good.
Yes, police recovered, not
All the-
entire, Lordship. I am not denying it. Police has recovered, but not
Okay, you
entire.
go there,
My lord.
you go there, their only objection is that, but you cannot compel him as per your,
No,
thing.
we are not saying that Lordship, he was supposed to Lordship divulge everything.
Mm.
Question is that Lordship, he has been granted protection to cooperate with the investigation. Cooperate means what, Lordship? He will not go there and he will just appear and he will say that I have done interim protection, I have appeared pursuant to the right of the honorable
if
court.
you want to
He has to
record his
comply to
statement,
investigation.
we are sending him again.
He will
My
say that
okay.
where does my lord
It is
this party-
submitted that though statement pursuant to the interim order, the statement of the victim has already,
Accused.
statement of the present petitioner accused has already been recorded. However, further statement of the victim is required to be recorded as the entire stolen material has not been recovered. Considering the above submission of the learned additional public prosecutor, it is provided that the petitioner shall once again appear before the IO within a period of 10 days or 15 days from today. In the meantime, the interim order passed earlier shall continue.
But
Case
we
diary
return the case diary
read
to
the case
Concord after
diary.
case diary.
Yes, return the case
Let
diary
it be on
on
28/11. 29/11.
29.
I am applied.
No,
My lord, my name may be different.
Yes, Mr.
I have filed wakalat.
Okay. Or Mr. N. That will be there,
I am applied.
Mr. Purva. Yes,
It was called for.
we are on interim,
Yes, ma'am.
cooperated,
Yes, ma'am. Do we appear?
Matlab case diary not received, Lord.
case diary not received on 23rd,
23rd.
23rd 11 interim to continue. Yes,
May I please, your lordship?
306.
Lordship, my learned colleague who is actually is the main counsel is on late
It is there?
district judge.
We'll wait for him. He is in district judge. What is the problem? We'll wait for him. Let him complete the lower court work and come here.
Yes, ma'am.
We'll wait for him.
Much obliged, ma'am.
In the case diary also not received, Lord.
Case diary not. It is submitted that the case diary call for is not received. So accordingly, release this matter when
24/11.
24/11.
Interim is
How many, when you have joined the profession?
1.5.
1.5. 1.5 you must know. You cannot make a submission that the lawyer is in a lower court, therefore he cannot appear before the.
No,
higher
but he's
court.
just arriving. He's just arriving, madam.
You cannot make a when you say that he's has some difficulty.
Yes, ma'am.
Of course, we can understand that a person is in the lower court, is not, but there is some decorum in the.
I'm sorry.
My lord. 30 to 30 submitted,
Search is submitted.
my lord.
Sessions tribal,
Yes, sir.
interim is there.
Yes, sir.
CS number.
My lord, 30 number 57/2023, dated 30/9/2023.
Sessions tribal. He commit.
Interim level continue till appearance.
That order is always been, but we will not repeat order. We only ask if sessions tribal after committal, if by magistrate before the trial. Otherwise, we will not be able to finish this
Criminal
longly.
Maybe not.
Yes.
38 everything.
Yes, tell us. This is 438. Yes, Burua.
The victim committed suicide in court of railway court.
My lord, case diary received lordship and along with the postmortem report, she committed suicide lordship. That
She
is,
committed suicide.
but question is that she was found 4 to 5 months pregnant lordship in the postmortem report. And my lord, this is was the person with whom my lord she last contacted on the
Over phone.
our phone lordship.
Anything.
And he prior to that lordship, he took the victim 2-3 times in the hospital. That is why the investigation is pending and his custody interrogation is required.
You do one thing. She died.
She died.
Have you preserved those?
Yes, the postmortem report already received.
No, not postmortem report. Anything blood
Yes.
sample of the
That is investigation is going on, lord.
fetus in the womb, so that we can send him to you and have collect his In-
DNA.
DNA and all. Have you done that?
That part is my lord, it is not clear from the case. There is
Suppose you arrest him, you interrogate him. He says that yes, I have done. Can you convict him?
the question is the victim is
Vital
17
question.
years old.
Huh?
Lord. Victim is 17.
We understand. To convict, what you require as an investigating authority?
What is the
That
material? Lord,
she died in a train accident, that is
not
established.
actually, Lord. The abatement is there, 306.
Okay, 3066 is there, abatement is there. Abatement on the basis of what will you prove? First, you will have to see that fetus is that he is related to it.
Or
So you
whether
have to have first send those to the forensic laboratory and preserve it. Then you have to collect his sample, then match it. If you have not done the first part, if you arrest him, he will whatever he says. This is not an admissible evidence. Problem is this: everywhere we are acquitting people. We can send him, even giving interim protection, that go and have your sample taken. But whether you have done your part, arresting a person is not it's not an important thing, certain. Have you done that? That from the womb, from the fetus, we have collected sample.
that I have to go through the again, my lord.
You go through it and come back. See, we'll take it up on Monday. Go through it, and if not, then we'll send you it to you. Otherwise, you cannot arrest him. We'll send him. We record that he is ready and willing to give his sample. You have your instruction from your client. Okay? You have your instruction from your client. Burua,
My lord,
guide them. And if you have not done nothing, he will be acquitted. who will
that
prove
part
that-
is okay, lord. But whether the abatement part was there,
Abatement part, how will you prove?
I have
Only meeting
because
and
lord,
telephone.
if there is some relationship, lord, then he must have, my lord, ask the person.
Can you presume
No, we
that
cannot presume.
he has impregnated her? And therefore he refused to marry her, therefore she committed suicide. Abatement will be there only.
Prima facie material is there, lord. Because he
That
spoke
we
to her 2-3
understand. That
times.
we understand. Prima facie materials are there. We can reject his bail. No problem on that.
My lord.
But what is the end result? What is the end? That is what we want, that at least investigation should be done properly.
My lord.
There are many techniques nowadays. In a case I have seen, teeth marks were there. No other eyewitnesses, only circumstantial evidence. Those teeth marks were not even sent. Nowadays, this can be tested. It's a rape and murder case. Very famous. So do no investigation. Don't his teeth and her that teeth marks were not matched. Even if that would have been there in the evidence, we could have convicted.
My lord. Mandel.
These are the things. Instead of arresting him, taking his statement, you do that so that you can take a permission, collect his matching, then you can link it. See, that is why she was pregnant, you refused. So this is why when
Mandel.
Monday. You also have instruction
get
from your client whether he's willing to have,
Oh, a lot.
otherwise will not give you any protection. Only condition that you will go and give that your sample.
One people like without entering order, they will arrest, he will.
No, no.
Will
it is not.
on Monday he will go to have instruction and then Monday will give you interim protection.
All right.
Interim protection subject to agreeing.
A lot.
Yes.
Mayor, please, your lordship, I'm on interim, my lord, I appeared, my lord.
My lord, he appeared, lordship, what he has done, he has took gold loan, lordship, by submitting fake gold. Now, in the FIR, lordship, it was stated that, my lord, when the gold was deposited, lordship, it was examined by their, some who are authorized, my lord.
They are having bank having
Then,
some.
my lord, 1,80,000 rupees was allowed, my lord, sanctioned to her, lordship. After that, she neither he still returned the, my lord, amount, and when the notice was issued, she has not appeared. That is the allegation against her.
So let the bank file a suit to will for recovery.
What about the, my lord, cheating, lordship? Cheating part is there.
Cheating part was done by the manager, my lord. In the FIR, Monish, he's not there before your lordship, my lord.
Where's the FIR? Let us see.
Page 13, my lord.
And what about that bank authorized? Goldsmith?
Wheeler was not.
Now they are saying, lordship, now India is still own statement, they are saying that they have, my lord, requisited another Goldsmith, lordship, then it was examined again, then he said these are all fake gold. That is why it is FIR has been.
So initially,
So when they
gold
have-
was because the moment gold loan is taken, they first verify through their own Goldsmith
My lord,
bank.
we deposited actual gold as per instruction. The manager and the impellant jeweler, my lord, they did something.
So according to you,
That is my instructions, my
you ought to file an FIR that I
Right. When this
deposited
manager was
that was
arrested,
replaced.
manager was arrested in 2017. He subsequently got bail, my lord. I was served with 41 notice, my lord. I appeared, my lord. Second notice I was served, my lord. I could not appear because of ailment, my lord. Then we filed this application.
that is,
Upon interim, my lord, again we appeared.
that is true, lordship. He appeared earlier, lordship, then 41 a notice was issued. After this, he did not appear, then obtained it.
Now you have done those tests and all.
Yes,
Any
now
part-
lordship, investigation is going on now as per their second, my lord, examination report, it is all golds are fake. Not only her, lordship, there are other persons also who obtained the loan, availed the loan, they are all fake. Lord.
So do you need their custodial interrogation? If gold are
He
there,
has-
parts are seized, reports are there.
But he appeared already twice, lordship. That part I leave it to lordship.
Considering appeared and stage of investigation.
Obliged, my lord.
My please, your lord.
Yes,
In the interim is there, your lordship, that the petitioner appeared for the
that cannot be the only ground. So as the FIR. Not
45
in all.
parties submitted. Lordship.
30. Sessions tribal,
magistrate trial.
Magistrate tribal. 386 interim to continue.
Till his appearance,
Till his appearance and filing an application.
my lord.
Actually, my view is that when charge sheet is filed, 430 interim is there, it should be made absolute till the corporate owner. This is my view. But we are saying that and what happens is there is a question of committal. If it is sessions tribal, committal court will say, no, I cannot keep bail. So therefore, what we are doing is nowadays at a new formula that it will be after committal till trial. That's why we asked this. Actually, interim is interim. What we, is it any necessary?
Definitely, one matter in written judgment, Supreme Court has said, lordship, that assuming 30 is filed. My lord, for that reason, my lord, if he has cooperated in the investigation, lordship, or person to the interim protection, he has appeared. Then, lordship, it is not that, lordship, when he is appeared, he will be put behind the bar.
That's
Only,
why.
lordship, in case of absconding or non-cooperation, then, lordship,
Then it's different. So therefore, with my view is that suppose he has cooperated, statement recorded, we have direction. Then anyway, we have had a mixed balanced formula now.
Obliged.
Indirectly,
also
we say
36
that someone after receipt of someone. So that someone is receipt. Yes,
36 case there is no receipt.
not receipt.
Before vacation, if
Everything is possible,
Then I-
provided we can have 28 or 29 hours in a day. Everything is possible.
No, 17-11, 17-10.
17.
Online.
Let's see the question. But it- The last question is that you are but call for the petitioner is on interim bail. We are taking a iron.
What is the affair?
Affair is at page 8. The informant availed a housing loan in the year 2019. He lost
Why you need your need custodial details?
because my lord, what he had done, my lord, the bank, he is one of the my lord, employee of the bank. While you see my lord, informant first avail a bank loan, my lord. Thereafter, those documents are my lord with him, and he created 3 fake accounts and 3 loan accounts from where he has my lord misappropriated an amount of rupees, my lord,
10 lakhs.
13 lakhs, and another from another account 4 lakhs, and then thereafter another fake account that is 17 lakhs. All these are
On her name,
on here on her name.
on the basis of those documents.
Those
And he withdrew all this.
All these to do. And that is one, and there is a pre-sanctioning process in the bank. If bank manager cannot sanction a loan in his own name by using the documents of others, there are some pre-sanctioning process of the bank. Although he is a manager, he was a manager at that time in the Himalayan. He has admitted to an agreement, my lord. Housing loan to an agreement, he is, my lord, undertook to return those amounts, but that is not done, man. One report is also there regarding the IOS report where he was called for in the before registering the case. He was called for in the police station, my lord. Was asked to refund, but not refund. It's okay. In the account, he leave the case. Thank you. Thank you. And in one way, he has also, my lord, admitted that yes, my lord, in his statement. Now, my lord, all the liability is shifted on the my lord, informant.
That case.
But if,
You are a trustee of public money.
he is cooperating with the investigation.
Cooperate.
Or if this material interview.
No, this will stand alone.
Pratik, kindly see the informant availed the loan in the year 2019. After he becoming defaulter, he lost the
She will be defaulter, obviously.
And-
She is not aware
Hmm.
that these are her loan, one DK,
So far as-
3 to DK construction, 1 to some Setia, all money transferred to those accounts.
So, so far as opening a bank account in the name of the informant, there
You
are
are a manager, all signatures, keys are with
So
you.
there
This
are
is not a case,
there are
public.
other officials who verify the property before securing any loan, and the
Who
credibility
knows
of
that
the
not
property-
only her, there may be some other
Other-
also.
there are
Maybe
that will
other.
come out. If kindly he is cooperating with the investigation.
That cannot be the only ground. In some cases, yes, of course.
Custodial, he already appeared, his statement has already been recorded, and will appear as and when required, Only question.
Not only that, you promise to return the money.
That is, if he,
registered agreement.
if she sent.
That I will return this, I have admittedly, I have transferred this, created this loan account, transferred to all these entities, now I'll return, that also you have
But
not.
kindly see if he said,
That been there, that you
Then
have
she would
already
have
done,
said he
I
would have-
would have
but
considered.
if he said please so Lordship, kindly see if he sent to the jail, how he will pay the return in the money.
Otherwise you will not pay. There may be
If
some,
he try
you
to,
are not entitled for any privilege,
kindly,
that
he
much.
already appeared, Lord.
rejected. There are
Thank
Perujal of the case that it's seen that the petitioner was directly involved in creating fake account in the name of informant and transferring, creating loan account, sanctioning loan and transferring the state amount to different accounts. Considering that the petitioner was the bank manager and he was a trustee of a public money. This court is of the view that the petitioner is not entitled for privilege of pre-arrangement. According to the president, applicant, the interim order says
Obliged, Lord.
yes,
Yes, this city was called for it. FIR is 9.
yes.
9.
What happened to, what you did to Noor Nahar?
Lordship, informant did something with. Lordship, case 18 is the agreement, Lordship, which is entered by the informant with the petition number with the address of the informant. Yes, 18 point.
Consenting,
Uh,
husband was not there.
Yes, that is different, my lord. Now the FIR is regarding my lord kidnapping and assaulting. So now the
No,
injury is my lord simple blunt. It will happen.
What is
Golden-
the page 14 is the FIR?
no, Lordship, 9 is there.
9,
What is page 14?
Case 14 was filed by the wife of the petitioner number 1
it is a cross.
against the present info. There was
9.
something, Lordship.
Lordship,
and,
kindly see
Lordship,
page
case
9, my
18,
lord,
Lordship.
present,
Space.
page 9, present FIR, my lord, present case.
Sadek Ali.
Sadek.
You are Sadek.
Sadek
Yes,
Ali and 3 others, my lord. Sadek, Tofar, Suleiman, Mukaddas, everyone is
Now who filed this FIR? Mohibul.
Mohibul.
Yes, sir.
And against Mohibul allegation is by Noor Nahar.
Yes, sir.
Noor Nahar is the
Wife of the petitioner number 1. Lordship.
or the Sadek.
Yes, sir. There is a agreement, Lordship, case 18. Actual fact is he entered in the bedroom of the petitioner number 1. Lordship, and people confined him, Lordship.
Oh,
and
she
something
now
else,
she entered.
that is admitted in page number 18, Lordship.
And
Next.
what about Mohibul?
Mohibul was, my lord, confined in a room and he was beaten up, my lord. Thereafter, some villagers,
Mohibul was beaten up by Sadek
Sadek, my lord,
because Mohibul was inside the bedroom of Noor Nahar.
no, that is a
Now
cross
Noor
FIR.
Nahar lodges an FIR.
Yeah.
Considering these are not allowed.
Must.
To appear within 10 days.
It is received.
May I please your lordship?
Yes.
Lordship, the matter may be passed off for the time being.
My lord, may not be required, my lord.
Stiti?
Yes, CD is there, my lord.
But-
CD is there, my lord. There is a Nazar, my lord, 21 years of age, and he voluntarily left with the my boy, my lord,
Okay.
because
Considering the material available on record, it is seen that the victim is a major and she
মই ভাল পাইছিলো মই নিজ ইচ্ছা মতে পলাই গৈছিলো
she eloped with the court. Considering in terms
In
of her
one-
statement recorded under
164
164. Considering the above, then
finish
Allowed.
adjournment
Whose name? Your name or senior?
Adjournment
Senior.
You have allowed your bail. No adjournment. Adjournment stands rejected, bail allowed. Yes. নালাগে repeat, repeat.
May I please, Your Lordship?
Yes.
FIR is in page number 11, Lordship. Total,
My lord, CD not received, my lord.
Any interim?
Interim.
No, no interim.
my lord,
When
4 has been arrested, my
Whether,
lord.
accused number 4 arrested?
No, my lord. There are 10 accused.
Ah.
I'm for the accused number 2,
Ah.
out of which 4 were arrested. That is accused number 1, who is the main accused, then mother, husband.
What is the affair?
FIR is page number 11, Lord. The forwarding report is on page number 19. Lordship. 4 were arrested. And they were granted bail also.
What is the allegation against you? Tell us in the affair.
That I have committed rape, my lord.
Yes, when? CD.
whether,
My
my lord, just after vacation or,
Let us have a try or 9.
lord,
My lord, only one player. That is come to page number 15, my lord, or 25. Sorry.
Yes.
My lord, the crime accused, that is the husband and father-in-law, they were granted bail, my lord. So
After
considering
arrest.
that- Yes, sir.
So we'll provide that. You will surrender and thereafter bail will be considered.
My lord, still that interim may be
Huh?
nah,
Done.
puja
Since you are relying on page 15, okay, hard to
25.
Huh?
Page
You
20.
surrender before whom? Police station or judicial magistrate first class degree who granted bail after. So accordingly, we will consider taking note of the fact that the co-accused has been granted. Go dear. Okay,
my lord, 19.
95, let us have that.
Public.
Yes, Mr. Dotto,
26, my lord. FIR page 11, my lord.
interim is there.
No interim, my lord. Accused number, that accused number 1 has been arrested, my lord.
So he is no cause of action.
No,
for it.
but that has been rejected, the earlier order. 2, 3, 4, and 5, my lord. Case diary will
Yes, Lordship.
be at the-
You are
I am for 2, 3, 4, and 5.
Habibur Paramani.
Habib Parmani arrested.
Huh?
He is arrested.
Okay. Habibur arrested.
Now remaining 4.
Lalsan
Lalchan,
and Anna.
Anna Khatun,
Anna.
Anna Khatun,
And what about Kalu?
Kalu Paramanik, and Fulchan Paramanik.
All these are
Family members.
family members.
Injury record.
Cases of 326, my lord. The injury report will speak, my lord. Previous order.
Yes, what is the report?
Lordship, that report is awaited and Lordship has, the witnesses only implicated 2 and 3, Lordship.
2 and 3, but what is the injury?
Injury report that is awaited.
Okay, the injury, Lanet, so case diary is heard Mr. N.J. Dotto, Lanet Pankit Road petitioner and Madam for the Lanet issue public. Though the case diary call for is received, however, injury report is not there. Case diary, according to the Lanet Regional Public Prosecutor, the implication is made against Lal's petitioner number
2 and 3, Lordship.
2 and 3.
Yes.
And not against the petitioner number 4 and 5. The petitioner number 1 has already been arrested.
Arrested.
Considering the above, the case diary is returned back. Same be produced along with the injury report of the victim on
Lordship, can it be after vacation?
give after vacation
Lordship on 14/11.
14/11. Considering the material available on the case diary, the accused petitioner number 4 and 5 are protected by an interim order,
Lordship.
which subject to the condition that they will appear before the IO
Malad,
within 10 days.
eh,
Yes,
Malad,
LR Mojumdar appears for the informant who has assisted the learned additional party.
if possible, Lordship, that lady may be protected.
Which lady? Anna Khatun.
Yeah, Anna Khatun.
Otherwise, there is specific allegation against her. but
Otherwise,
She
my
has
lord,
brought the
Yes,
doubt.
yes. Let me
Okay,
come.
okay. You have not been granted interim on the first day.
Yes, Malad, I am praying on the ground, Malad, 439A of the Assam Amendment Act, Malad, where it says, Malad, women should be protected.
See,
Lordship,
Right, I have also
no,
annexed.
no.
I have also
That
annexed.
is, but who inflicted?
Who
No, that
inflicted?
will not.
that is your 2 and 3.
2 and 3
Three is
specific,
also so.
specific allegations, she has brought the doubt.
I have also annexed, Malad. I also got injured, Malad. This is the picture. Lady,
Okay, for the time being, for the
Fine.
time.
I am obliged.
Even if that-
Okay.
But I have one better. I'll come later on.
Okay, we'll come back. Against Probal, nothing is. Probal, nothing is there, 164. And even her, he will not be even treated as a trustworthy. Because one, in deposition, she has changed everything.
And in the evidence in chief Lordship, he has not stated it.
Even in evidence, no physical or something is there. Hard. Principal learned counsel for the petitioner also hard. The Bodwa learned petition for. The present application is filed under section 439 of CRPC for grant of bail, regular bail to the accused petitioner who is surseated as accused in session case number 107/2023 under section 366 plus 371 IPC, and he is behind bar since
26/4/2020.
since 26/4/2023. Peruse the scan copies of the statement of the victim card as well as her statement recorded under 164. From the perusal of the 164, seen that she has basically made allegation against the other accused and other accused, not against the present accused. And similar is the fact in the case, similar is the situation so far relating to her statement and testimonies made before the learned trial court below. Full stop. No allegation of any physical intercourse has been alleged against the present petition. Considering the material available on record and considering also the fact that the victim has already been examined, though some of her cross-examination still remain to be done. The present bail application can be released on bail of 2022 with the following condition. While parting with the record, it is made clear that the observation made in this petition, made in this order by this court is made only for the purpose of grant of bail, shall not be treated to be any comment on the merit of the case.
My lord, since the trial is going on, Lordship, he will not, my lord, try to, my lord.
No,
Taken
that is just, he will not even try to go near this girl or try to contact
My
by
lord.
any media, including social media,
My lord.
WhatsApp, etc. Like that will be there.
Wait, Mr. What's the default bail, Lordship?
You are only on default bail, not on merit,
Only on default.
not on merit.
Merit lordship already
Rejected,
rejected
Lord, earlier, Lord.
By whom?
by Justice Kolita.
That has been
Mrs. Kolita.
rejected.
Yes, yes.
So it should go to that court.
Already on that
merit
court, it was placed, lordship. It was listed on that court. But on that court also, lordship, Honorable Justice M.K. Kolita has heard the issue regarding the default bill or not.
But on merit earlier, Lord. I am only on default bail.
Justice
Only on default bail.
has
He has been-
directed me to produce any
he has-
judgment, any to the prosecution, stating that he is not in default. He will not get the liberty of default.
He has been behind the bar for last 138 days. Lordship.
How
And
many
my-
witnesses? How many witnesses are there?
Witness,
We cannot go, we will not enter into those parts.
Lordship. My prayer for
Of course, there is no bar on even again hearing on merit at a subsequent stage. Depending upon the stage of investigation and all, there is no issue on that.
Lordship. Lordship now may kindly come to the charge sheet, page 36. Page 36.
What is the law tell us? We assume that your argument is correct.
Lordship, there are total.
We assume
Yes,
part search sheet is filed.
Lordship.
Now, what is the law?
But Lordship, the
Whether part search sheet will allow you to go on default bail. That is the,
that is-
we agree that there is a part. Now tell us the law.
Lordship,
Facts we have accepted.
but they on the guard of Lordship further investigation. They cannot open the.
Here's the law.
so lordship, once it is admitted that part 30 has been filed, they are entitled to default bill. Therefore, I am opposing that.
Yes,
But no part 30 has been filed. It is a final 30. The final report has been filed by CPI.
Yeah.
After taking into consideration all the relevant
Where
material,
is that?
That I will show you, Lordship, whether it is final report or not.
the final report. Lord.
Lordship may kindly see page number 37 for a moment, 36, the charge sheet. Lord. I was remanded to custody on 26/5/2023, Lordship. And after that, 5 more accused persons have been arrested, Lord, after my arrest. Lordship may kindly see Annexure 7.
No,
page
no,
30.
final report is you were arrested on which date?
Arrested on 25/5/2023.
25/5/2023.
Forwarded to custody on 26/5.
26/5 custody.
Lord. Thereafter, after my arrest, 5 other persons have also already.
For the record, we will come to the others.
Yes.
When the search sheet was filed?
Charge sheet was filed, Lordship, 19/8/2023.
19/8/2023.
Prior to Lordship, within 90 days.
73 days, lordship.
Not
Lordship
7.
calculate.
Not 73, Lordship.
How much?
2
2 months, 19.
months, 1 week, less than 3 months.
1 week less than 3 months. So
And
Just
the
within
Lordship,
the time.
within the Lordship. But under.
now you want to interpret me the search sheet that this is a part. search
Yes,
sheet.
Lordship. Yes,
That
that is
is-
what I am saying. That is my whole case.
That will decide after vacation.
Lordship, he is behind the bar, Lordship.
Let him be behind the bar.
No, Lordship. Because they are Lordship may kindly hear me for something. Because Lordship, in this charge sheet,
See what we are saying.
4
is
numbers of.
Before puja, we are not entering into all this.
But Lordship, he is behind the bar for me. His prayer for people has been rejected by Lord CGM. By observing that investigation pertaining to him is complete. Investigation of the case is not complete, Lord. That I will show you,
That
Lordship.
is the objection of PCM code.
And
That
Lordship,
is not the law, lordship.
from the language of the IO also, investigation is going on. I will try to satisfy Lordship. Lordship may kindly say, charge sheet is filed against 4 accused persons. And Lordship may kindly see the operative Lordship part, page 45, Lord. Last para 16.16, Lordship. That the IO cannot be permitted to do, Lord. Para 1.16, 16.16. In this case, further investigation has been kept open to unearth the larger conspiracy and the role of the accused, one Mustaq Ahmed, Mukhtar Hussain, Nazrul Islam, and Dildar Hussain, and others, if any. So lordship, their investigation is not complete with regard to the offense.
They have not continuing with the investigation. They said if necessary, we will do this.
But let's say after that, the conduct of the IO and the trial court, everything will be clear. Lordship. I will take lordship not much time.
That's why I'm saying, let us take it. How many days you are behind?
138 days.
You be for 15 days more.
Lordship, only 2 documents it will be clear. Lordship, only 2 documents. Then lordship, they filed the petition. Lordship. Then lordship may kindly come to the lordship page 68 for a moment. Lordship. Page 68. Be it noted, is the order of the learned CGM lordship after taking cognizance. Be it noted here that the case diary of this case has been submitted to understand the factual circumstances of the case in progress of the investigation lordship, after filing of the charges. I have perused the case diary as submitted by the IO after giving my due deliberation and the grave nature of the offense as well as the connected circumstances. The IO is giving a further time till 12/9/2023 to submit final form in this case. Thereafter, lordship, on to next parallel, next page, 69, my default bail prayer has been rejected on 2/9/2023 by learned CGM lordship, holding that I am not entitled to default bail because in investigation pertaining to me is complete, lordship. And thereafter, lordship, the IO has filed a petition, lordship. Page lordship 74. That is very important in this lordship. Page 74 and extra 11. IO has filed this petition before the learned CGM after filing the charge sheet. Para 3, page 74 of IT. That on 21/8/23 charge sheet number so-and-so, dated so-and-so, under section 120B, raid 340 to 380 at 395 of the IPC against Nur Mohammed alias Kalia, Azizur Rahman alias Azimuddin, alias Riyazul Islam alias present petitioner lordship, Mujibur Rahman was filed in this court, honorable court. It was also submitted that the legal proceeding against accused Jumuni Raba may be evaded due to her death on so-and-so. It was also submitted that the further investigation has been kept open to another larger conspiracy and role of co-accused person.
You are taking a risk of a CAV and behind bar till after puja.
Thereafter, lordship, that it is the
What to do if you do not understand? Yes.
should not take. Thereafter, lordship, he has paid further time for completion of investigation. That it is submitted that further investigation is being conducted in order to gather evidence and establish the role of other co-accused persons, namely so and so. That during the course of further investigation, remaining accused persons have been examined and the defense taken by them are being verified. That Forensic Science Laboratory Guwahati has furnished extraction of the mobile phones of accused persons and the same is being analyzed. Several new mobile phone numbers surfaced during the course of further investigation and their involvement in the case is being investigated. That there are several witnesses whose examination is necessary for this case is also to be examined and cross-verified. The further investigation of the case is a crucial step. It is therefore most respectfully prayed that this honorable court may kindly be pleased to permit the continue the further investigation in this case to unearth the larger conspiracy and role of remaining accused person involved in the crime in the interest of justice. And the court also, learned court of CGM also observed that considering the material on the same day, 12/9/2023, considering the materials on record, including the case, that I find that it is necessary that the investigation should not be jeopardized at this stage, and the conclusion should be reached as early as possible. Hence, given the grave nature of the offences and the stage at which the investigation has reached, I am of the considered opinion that further time is required to be given to the IO till 3/10/2023 to submit final form in this case. On 3/10, again the IO has filed the petition. Again, time is granted till 3/11 to submit final form. If the final form is yet to come, lordship, what was the earlier charge? It was not a final form, lordship. Only to defeat my right of default bail, lordship, the IO has filed this charge sheet without completing the investigation. The Honorable Supreme Court has also observed that
Sorry for that.
this is the last order of the lordship land court below, extending time till 3/11.
No, Supreme Court judgment. Here's the law. That we have understood.
Lordship. This lordship, lordship para 23, 24, 25, 27, 32 lord.
Yes, read it.
I don't have one copy, lord. I will be allowed to read from.
But what is required, that is not with you.
I had
Huh?
lordship, I could not do.
Huh? Only knowing law and fact is not advocacy. You must know many other
Lordship,
things.
I got
You must know many other things.
para 23. Page 7 lordship. It is also to be noted that as per the scheme of CRPC, an investigation of a cognizable case commences with the recording of an FIR under section 154 CRPC. If a person is arrested and the investigation of the case cannot be completed within 24 hours, he has to be reported before the magistrate to seek his remand under section 167(2) of the CRPC during continued investigation. There is a statutory time frame then prescribed for remand of the accused for the purpose of investigation. However, the same cannot extend beyond 90 days as provided under section 167(2)(a)(1) in cases where the investigation relates to an offence punishable with death, imprisonment for life, or imprisonment for a term of not less than 10 years and 60 days, as provided under section 167(2)(a)(2), where the investigation relates to any other offence. The relevant section further provides that on expiry of so and so date, as the case may be, the accused has a right to be released on default bail in cases he is prepared to and furnishes bail. Para 24, this right of statutory bail, however, is extinguished if the charge sheet is filed within the stipulated period. The question of resorting to a supplementary charge sheet under section 173(8) of the CRPC only arises after the main charge sheet has been filed. And as such, a supplementary charge sheet wherein it is explicitly stated that the investigation is still pending cannot under any circumstance be used to scuttle the right of default bail. For then, the entire purpose of default bail is defeated, and the filing of a charge sheet or a supplementary charge sheet becomes a mere formality and a tool to ensure that the right of default bail is scuttled. Then lordship para 25. It is thus axiomatic that first investigation is to be completed, and only then can a charge sheet or a complaint be filed within the stipulated period. A failure to do so would trigger the statutory right of default bail under section 167(2) of the CRPC. In cases of Union of India versus so and so, which was a case under the Narcotic Drugs and Psychotropic Substances Act, on finding that the investigation was not complete and the charge sheet was not filed within the prescribed period, denial of default bail was held to be in violation of Article 21 of the Constitution of India, and it was further held that even the twin limitation on grant of bail would not apply. Lordship. Then lordship, para 27. Therefore, in light of the above mentioned principle discussion, it can be seen that the practice of filing preliminary reports before the enactment of the present CRPC has now taken the form of filing charge sheets without actually completing the investigation, only to scuttle the right of default bail. If we were to hold that charge sheets can be filed without completing the investigation and the same can be used for prolonging remand, it would in effect negate the purpose of introducing section 167(2).
What is the power of further investigation? When can be exercised? What is the provision?
It is
If-
173.
173(8). If something new comes out after the completion of the investigation, it's clear from the language itself. If some new material, new evidence comes out,
Then
then
also it will have to revert back to the for default bail.
no, Lord.
No.
In this case, Lordship, the investigation is not complete with respect to other accused. They are named in the FIR, Lordship. Only to defeat my right, the charge sheet has been filed. And Lordship, till now, although it is a session tribunal case, Lordship, the case is not committed, Lordship. I am being remanded again and again, Lordship. And the learned CSM is awaiting for final form. And the IO has also, Lordship, for time. And Lordship, they have filed a written objection, Lordship. Lordship will find in the Lordship. Their Lordship. They have also admitted, Lordship.
But you will, for sure, we do not know what is the result. For sure, you will have to be inside during the puja. That is for sure. We generally we indicate certain things when it is not possible, but you are insisting.
Lordship, that is lordship because he is behind the bar. Lordship,
That's
for
why
what
we'll have
reason?
to be, suppose we allow this petition, it will be, judgment will be delivered after it. As simple as that. That is what indication this court is giving you from the starting point. And that hurts us. Suppose we allow this petition, we cannot pass a judgment.
Lordship, another judgment of the Madhya Pradesh High Court. This lordship dated 12/4/2016, lordship. Para 13, 14, 15, lordship. Para 13, lordship. Para 13, lordship. When the provisions of section 173(2) and 173(8) of the CRP simply empowers to file final report and to file supplementary report, then no right is accrued to the investigating officer to keep the investigation pending against a particular act. It is not permissible for the investigating officer to file a charge sheet against few accused persons on believing the evidence of some eyewitnesses or other witnesses by believing them and to keep the investigation pending against the other accused persons with the pretext that the testimony of such witnesses is yet to be examined for remaining accused persons. The investigating officer cannot be permitted to create any impossible situation before the court. If a crime is registered and the investigation is started, then it should be completed within a particular span of time. Then para 14, the investigating officer cannot be permitted to keep the investigation pending for some accused and to file the charge sheet against the arrested accused to defeat the provision of section 172 of the CRPC, so that bail should not be granted due to incomplete investigation to the persons who were arrested by the investigating officer. But such procedure is commonly practiced in our state by a few investigating officers that they keep the investigation pending for some of the accused as a right in the light of the provision of section 178 of the CRPC. However, due to such procedure, the session could start trial against few accused persons, and in the meantime, supplementary charge sheet is filed by adding one or two accused. Thereafter, retrial starts if previous trial is not completed, and again a piecemeal charge sheet is filed against remaining accused persons, resulting in a retrial or a fresh trial. Such activities of police create multiplicity of trial against accused persons who were arrested earlier.
Yes.
Lordship, whether fact is that whether it is a charge sheet, final charge sheet or the part charge sheet. There is no such thing in the CRPC that part charge sheet. There has to be charge sheet. Once investigation is complete, evidence collected by the IO will have to file charge sheet as per section 73. Lordship. Conditions are there, what are to be fulfilled while filing the charge sheet. Here in this case, Lordship, IO has collected the evidence, documentary evidence as well as the oral evidence. Lordship. And accordingly, he has filed the charge sheet, Lordship. In the last para of the charge sheet, Lordship, on 15.3, he has clearly stated that investigation is complete and only with regard to accused number so and so, further investigation is incomplete. Further investigation is required, Lordship. And therefore, subsequently, he has filed a petition. There is no bar, Lordship, in
Further investigation.
further investigation. It is the inherent right of the IO to investigate further under section 173(8), Lordship. There is
Third in part, please this matter for further hearing on after vacation. Ten 11.
Hello.
Partner.
You have invited.
Only thing is that he was behind for so long that
So what to do? We are humanly, it should be possible. After 78 meter dictating, correcting, it must be possible. So we have kept it as a partner. We'll pass this order after vacation. We'll have to do it. Yes, next case.
Hello.
May it please your lord.
What is it?
It's an
Order. What?
this is an
IA
I in an appeal. It's an appeal
for bail.
for bail, my lord. I am.
What is the offense?
Offense is, my lord, under section 4 of the POCSO Act.
4.
Four. He has been convicted under section 4.
Hmm.
And he has been sentenced to 10 years of rigorous imprisonment along with a fine
POCSO.
amount of 2,000.
List of the package. Given that after await service report in respect of respondent number 2 and 3. Release this matter on 17th of November 2020. In the meantime, the registry shall put a note on updated service. Bibliable.
May it please your lordship, lordship, as per office note dated 7/10/2023, lordship, await for service report, lordship, upon respond number 2.
Okay. In view of office note dated 7/10/2023, await service report in respect of respondent number 2 and matter be listed after 4 weeks in the 4 weeks with an updated service report.
Oblige, lordship.
May it please your lord.
Yes.
Lordship, in this case, lordship, we have taken steps on the respond number 2 by both registered post as well as usual process. Lordship, the service report with respect to lordship registered post has returned. Lordship. Lordship will see lordship office note dated lordship 9/10/2023. Lordship. AD card in respect of the respond number 2 has been received back after service with the illegible signature, which is placed at flag X in the part 2 file. And with regard to usual process, AD card, no service report is there.
Yes, registry in view of office note dated 9/10/2023, registry to is to will call for the case diary from the OC of Tinsukia police station.
Lordship, in this case, the charge sheet submitted, the trial is going.
Okay,
It has to be called for
registry should issue reminder for the
case record.
case record
Along with case. Of lordship, POCSO case number
in terms of order dated 23/8/2023.
POCSO case number
No,
18.
no, the Tinsukia PS station
During pendency, lordship charge sheet is filed
during pendency
Pending.
of this.
of this bit. And the trial is
Okay,
going.
it is submitted that during pendency of this present petition, charge sheet has been filed in Tinsukia PS case number 401 of 2023. Accordingly, registry to call for the scan copies of the case record as well as case diary from the
Court of lordship,
court of
additional session judge comes
learned additional session judge cum special special judge POCSO
Tinsukia.
Tinsukia.
In POCSO case number
In POCSO case number
89/2023.
89/2023. Full stop. Awaits service report to Israel process. Full
But
stop.
I may be allowed to take that pro police
Uh,
station.
No. The petitioner is allowed to take fresh step.
Pro jurisdiction police.
How can we burden the police with all this? They have some other jobs. They are not.
Because in this case, lord,
This can happen in a state like Arunachal where we do it. But in Assam, we cannot burden them to make a postman. You take fresh step, we'll await for the issue reminder as regard. Registry also to issue reminder to the learned district magistrate in Sukia as regard service report of service upon respondent number 2. The petitioner shall take fresh step upon respondent number 2 to register for list of the
let me be please behind the bar.
give it 22nd of November.
But I apologize for my repeated participation earlier. Lord. The only thing is that he was behind the bar. Lord.
No.
That
See,
lordship,
in this
Yes, sir.
country, in this state, many people are behind. Not only your client.
Right.
And it's not that we are not taking cases.
lordship. I was not saying that.
it's not that we are not taking it. To the level base, we are trying to do justice. But sometimes there is a problem. If I make this case CAV, that will hurt my conscience anytime that a person is behind bar and I have not been able to deliver the justice.
Lordship, yeah,
So therefore, I have no way out to get out of that, but to make it part for your insistence.
I'm sorry, Lordship, for that
Result is
repeated
there.
purchase.
So that's why I say that advocacy is not only knowing law
Lord.
and facts.
Obliged.
My lord, in IA, my lord, the honorable court directed the superintendent of jail to file a medical report of the epilepsy for consideration of
Consideration of
suspension of section, who was convicted under section 10 of the POCSO.
you are fine now.
Yep.
You are fine now. You had some lung infection. Your heart is absolutely fine. And lung infection antibiotic treatment has been started.
So, my lord, overall, I am facing various physical ailments, not
So
only that.
all you are facing more mental than physical. The report is there. You had complaint of breathlessness, breathlessness and exertion. So therefore, your X-ray of test is done and ECG done for the to exclude heart disease. Heart is absolutely fine. So for relating to the lung, there is some infection. For that infection, antibiotic has been started.
That may be my lord. So, on merit,
So-
my lord, considering his old age,
Huh?
we are praying because the offense is very minor.
No.
Offense is minor. What minor offense?
5 years notice.
Huh?
No,
5 years.
actually, charge was framed on wrong
5
footing, my lord.
5 years.
Not, how
No.
can it be minor?
He ought to be convicted actually for commission of offense under section 8, not on 10. If you lordship read the
So,
Yes.
what is the victim state? 23rd of November.
23rd of
November. Okay. Let this matter be listed on 23rd of November for hearing. If the hearing could not be taken, the IS will be considered. We'll see on that.
LCR, your lordship.
Okay.
LCR
As LCR has received. I got
much. Charge sheet has not been filed yet.
Huh?
Till tomorrow.
Huh?
Till yesterday. Charge sheet has not been filed.
Lordship, we have taken instruction from the IO Lordship. So as my learned friend has submitted charge sheet not yet been filed till yesterday, Lordship. But we just now we have received the information, Lordship, as per the IO, Lordship, the CS has been filed.
Okay.
And they have also provided us the number, CS number.
It is submitted that. Huh? Is there, can now we can
Lordship.
okay. It is submitted that after completion of investigation, the charge sheet has already been filed.
Not.
Being
Being case number 53/2023, dated 13/09/2023.
considering the nature of allegation, this court is of the view that the application for bail can be considered by this court. More particularly, taking note of the age of the victim as well as accused. Accordingly, registry to call for the scan copy of
LCR.
LCR.
Record is not different.
Yes, tell us, what is the number of the case?
Number is on- Notice, Helem, in respect of Helem PS case number 61/2023.
Hmm.
Pending before lordship,
Will be POCSO?
no, not POCSO lordship.
Huh?
3668.
Okay.
It should be POCSO.
No.
This is a minor.
Minor.
This is the minor. Pending before judicial magistrate purpose, go to this one.
Or you want to go there?
Helem
Because
PS
without having the record, we cannot grant you bail. If you say that case is file, we will give you a liberty to go there and file a bail application. Or we'll call for the scan copies and
We'll go for.
okay. Charge sheet has been filed so with a liberty. Charge sheet being switched.
Yes, sir. 53/23, dated 30/09.
Charge sheet number.
53/2023, dated 30/09/2000.
Order copy also.
It is there.
I know if I take 1 hour time, my lord, everybody will give me. I know, that's why.
Yes, Vishal.
If my landed
It's a
friend.
time to do motion,
No, I understand.
isn't it?
Otherwise, no,
Time
that
to do
actually I am confused by the heading. Earlier motion, admission, order, and hearing. Nowadays, my lord, top of the list and my lord, there's Quasman.
That Quasman is my
Very
idea.
new, man, very new. Whether it is for final disposal or it is for fixing and therefore here.
Quasman is basically, I proposed it because it's a mix up. So many cases are for Quasman.
Yes, that is-
pending without any.
That means nowadays we can take it as a
So-
Quasman means for disposal.
For disposal.
So then, my lord, after vacation, my lord, any that, my lord. If because
Quasman and to an extent criminal admission is also for disposal.
no admission always, your lordship can dispose of them.
Yes.
In admission, that is why it is called admission hearing.
Now Quasman, what do you want to pass?
No, my learned friend want to.
Procedure followed by the learned magistrate is out and out wrong.
That my lord Priyanka Srivastava case.
156P. Besides Priyanka Srivastava, there are many other cases of Supreme Court. There are cases of our own High Court, Torun Sharma.
My lord, there is a question to be decided, my lord. Whether on the basis of that, my lord, the FIR will be quashed.
I think you have a good case.
Yes, he has a case, but whether, my lord,
So that good case will take after vacation.
no one.
What do you say?
My friend, we want accommodation. Let it come
No,
after
Okay,
vacation.
we'll blame it to Mr. Mohan.
All right, I take it.
Okay, on the prayer of Mr. T.J. Mohanta, learned senior counsel, the matter stands adjourned and be listed on
Let it be after vacation, my lord.
vacation.
No date may be given.
No date. Okay, no date. Okay, after vacation. Something from him also. Any,
Yes. No,
any interim order?
Yes,
yes, he's
Interim
enjoying
order.
it in order.
Shall come.
Interim order pass earlier. Sir.
We want to, where civil suit is going on. There, my
No,
learned
there-
friend has.
Whatever going on,
Only
going
civil
on.
On merit,
Now
my lord, I have a case.
this is, we are having how many days? 2 days plus 4 days.
Yes,
6
Four
days.
days.
These 6 days should
My
be
lord, yes,
devoted to eviction,
Motion, yes.
bail,
Yes.
people are inside jail and not for all this passing and
Yes.
questions of law.
Problem.
My lord.
And where is the other case? One case is there, that case, CBI case, we'll simply adjourn it. I thought it should not be a part heard matter because though we have heard it, because it's ultimately person is behind or otherwise I'll have to pass as well. We just inform both the council. Yes, next.
No,
Part of the release this matter after I guess give a date or immediately on given time, huh? 9 left. Huh? Okay, we'll get it.
5-1.
No, 51, notice
May
55.
Yes,
Service is awaited. Okay?
in view of office note dated 28/9/2023, await service report and release this matter
Thing is,
after for it with an updated.
thing is that my lordship matter is pending before the court below on 19 my lordship. What available warrant was issued. Yes, next
What
day
is this matter about?
matter relating question of the statute my lord. Actually, petitioner on the way to Sibsagar to Guwahati. Allegation against that his Creta car knocked the vehicle my lordship. Out of that accident, my lordship, one person died, my lord. If your lordship kindly go through the FBI report, my lordship, that is a page 44, your lordship. Oh, sorry, your lordship, 34.
What is the next date?
Next date on 19, my lord.
19th of what?
October.
You seek an adjournment.
My lordship, thing is that
19 for what?
appearance of the accused person.
You
That is
seek
the,
an adjournment. This is an
that was-
accident case. Only.
yes, my lordship, in the previous occasion, we took adjournment, but court is on view that no, in the next that you have to appear. He is in Bangalore, my lordship, he's a sales manager of Bibron Private.
Okay, since everybody is in urgency, we'll hear if it's a case is made out, we'll consider or we'll decide. Why were you waiting? Respondent, who is respondent number 2?
Respondent number 2 is the informant, my lordship.
Why do you need informant in the criminal petition? Is it a CR case?
PRC case.
Then argue,
Your lordship, kindly kindly go through the page number 33, my lord. The MBI report, my lord.
30.
34, my lord. MBI report, my lord. Your lordship, kindly go to the paragraph number 11, my lordship, the last, my lordship. Damage due to the accident, my lordship. No damages seen, my lordship. Place of occurrence with time. Then remark number C, my lordship. The vehicle was found mechanically fit at the time of inspection. That was made on the 13th of 15th December 2021, my lord.
No,
Yes.
you are straight away going to the report. What is the case about? How it happened? What is the allegation against you?
Yes.
We are not getting nothing.
Yes, my lordship. Apparent page 20, my lordship. And then 21, my lordship. Particular. May I read your lord?
So according to you, there is no damage to the scooter.
Both the vehicle. Both the vehicle.
So therefore, no case is made out.
No, my lordship. That is not my plea, my lord.
What is your
Thing is that, my lordship, if a car knocked a by vehicle, my lordship, definitely there are some maybe damages, my lordship.
Yeah.
That was not seen, my lordship. Another, the owner of the vehicle, my lordship, the rider, vehicle of the rider, the medical document is there, my lordship. That is very clinically simple, my lordship. One man died, my lordship. The person who ride the bike is only a simple injury was done. My lordship, thing is that
There may not be any injury. The spinal cord may got damaged.
no, my lordship, clinically it is simple, my lordship. Why I am before your lordship on the way of that occurrence place of on the day of accident, my lordship, I am on the way to Sibsagar to Guwahati as I am on the office duty, my lordship. When I saw a vehicle lying in the road, my lordship, I stopped the car, my lordship. Then I himself called the police ambulance, my lordship. by dialing 100, my
Very
lordship.
good. You give this evidence.
Yes, my lordship.
You give this evidence before the court.
Yes, my lordship, I am done as a Kus Martinian, my lordship, and as the new definition that is Kus Martinian, which are included in 134A subsection 1, my lordship, which is inserted newly, my lordship, by amendment 2019, my lordship. I have done as a responsible person, I am doing, but police drag me in this act. That is why I am before you.
See,
Yes, sir.
we are on a 482.
Yes, sir.
There is a specific allegation that AS04Y9496 scooter was hit by AS01DY2727 scooter.
That is my car.
This is the FIR.
Yes,
This is
sir.
your vehicle. There is no dispute on
Yes,
that.
my lord.
The MBI report says that vehicle is
Not damaged.
not damaged.
Yes, your lord.
So according to you, since the vehicle is not damaged, this court under 482 should cause the search
Not because of that matter.
for what reason?
For both the bike and car, my lord, both
Okay.
Yeah.
Not only the scooter, there is no damage to the bike also.
Yeah.
So therefore there is no accident. That presumption we'll have to take under 482.
on that basis, my lord, abuse
On
of power,
482.
abuse in that the prima facie case is not made
Hmm.
against me because only because of that, my lord, I call the police person
Hmm.
to help the victim, and only for that I am dragged into the prosecution, my lord.
You have two options.
Yes,
I am dictating the right now the order
no,
dismissing or otherwise option is used. This cannot be a ground under 482.
I will satisfy your lord.
Already
Well,
search it has been
huh?
filed. Search it has been
Search sheet has been filed
I will satisfy.
today.
No.
Cannot be a ground for first. Only for the reason that if stay in Bangalore, that involves many other persons, many other litigation, life of many other people. The prayer of the learned country for the petitioner, because they adjourned and released the person. Give it.
Highly obliged.
Yes.
May please the lordship. Lordship, as per office note dated 9/10/23, the
Service
service
report
is
is
awaited upon respondent number 2.
Why you should wait for the service?
Lordship, case ID has also not been called.
CD has come up.
City has come. Now, tell us, why should we wait for the case then? What is the case about?
Lordship, the case is related to quashing of the FIR.
What is the FIR?
Lordship, the FIR is at page 33.
30?
3.
Lordship allows AI.
We will not allow you.
But-
We will allow her. There is a stay? Is there any stay? What is the offense?
Lordship, otherwise CD is up to lordship, not. up
What
to
is
date.
the offense? Tell us from the
Offense is
FIR.
regarding lordship, the lordship kindly come to page 33.
30?
33.
Yes, I'm
of the
here.
petition. Yes, lordship.
What is the offense?
That these two persons have raised some unfounded allegations.
What unfounded allegation?
Under section lordship 2
What unfounded allegation?
509,
We have not received our payments.
177, 211, 354, not receiving their payments on time.
Uh.
So
So what is the criminal offense?
perhaps that is not better.
Are having the city?
Yes, sir.
Yes, give us.
It is not up to date. Okay.
Who is the informant? Is it required for quashing informant is required?
Formally required, otherwise.
Okay,
process
our
can-
learned counsel for the petitioner. Service report in respect of respondent number 2 is awaited. Full stop. The learned counsel for the petitioner prays for an interim protection in this regard. Full stop. The FIR from the bare perusal of the FIR, it is seen that the allegation is very vague and to the following extent. 1. The present petitioners
Yes,
have raised some unfound allegations against one Dr. Ajit Tiwari, head of the department in the Department of Agriculture Engineering, Assam University, Silchar, comma. Said Dr. Ajit Tiwari is not an informant in the case. Next. It is also alleged that they have, the two petitioners
Yes.
have sent some mails to the registered vice chancellor and to the ministry. An allegation is that such action has been taken by the accused to injure and harass a lady faculty and also to tarnish the image of the university. Comma. From the this court also have perused the FIR and the statement of the informant. The said statement is also to the said effect only. From the perusal of the FIR as well as the case diary, this court is of the view that no prima facie case cognizable under law is made out. Considering the same, it is provided that until further order, the investigation is staged.
still returnable therefore.
Still returnable.
Sorry to interrupt. The emails are sent by petition number 1.
Whatsoever, that is not. The police will register whatever is. This is a case of causing why you did not get a stay, we do not. Yes. Keep the case diary. We have said it. We will decide on the next.
Not.
What is this?
Mate,
You are sitting from morning,
my
so I have no way out but to hear you.
lord, only thing is this, my lord, I have taken steps to take.
My lord, I have appeared, my lord, for
Oh,
point
they have
number 2, my
taken,
lord.
they have appeared. So,
That's
my lord,
very good.
Yes.
fix for hearing, my lord, after that.
I'll file my
Please
objection.
for admission or admitted already?
Not admitted, my lord.
Not admitted. What is the issue?
Issue is, my lord, they have filed a case under 138.
Ah.
Previous to that, I have lodged an FIR that the check theft got lost.
Okay. This matter is ready as regards service. Accordingly, list this matter in the admission column after vacation.
I'll file my objection. Written.
In the meantime, what
Yes,
object?
my lord. Because some documents are not brought on record, my lord. So I'll bring, my lord. Okay.
You bring in record, but in quashing, what objection do you?
Interim order.
Interim order passed at SL13. Please this matter on give a date. 15th of May.
Obliged, ma'am.
Admission? Left to Bani.
My dear Lord. My lord, in this matter, I am before your lordship, my lord, agree to an order whereby charge has been framed against the petitioner, my lord, along with other accused persons.
Okay, where is the scan copies? What is the allegation?
Allegation, my lord, as per the FIR, my lord, some person has brutally killed one Satro Bay, my lord.
Hmm.
My lord, as the charge framed, my lord, charge is as per piece, my lord.
What is your name?
My lord, Bimal Singh Bay.
You are Ham Singh Bay, Bimal Singh Bay.
I am Bimal Singh Bay.
Bimal Singh Bay. Whose statement?
My lord, the prosecution relied upon 10 witnesses. Out of them, no one has mentioned about a petitioner.
Where is that?
My lord, I have next the charge sheet, my lord.
No, no, not charge sheet. We want a 161 statement.
161 statement.
Case diary.
Yes, my lord.
Who
I
are,
have-
who?
I have managed a statement, my lord, from page number 27 onwards. my lord.
Statement of the one recorded by under 161.
Yes,
Where are those?
from page number 27. And I said,
In your petition?
yes, my lord.
Page 22.
27.
Then
Then, my lord, next at page 28, my lord, statement of witness number 23, my lord. There, Caesar witness, my lord, were not eyewitnesses.
okay. 2 entries is there. Then
At page number 29, statement of witness number 4. According to him, he was the eyewitness, my lord.
this is Babu. Dorsing.
Endorsing him. Here only name of Sesson Rangpi has mentioned, my lord.
Now who are these other two companions?
One, my lord, Hemsing Engti, and
How do you know that?
yes, my lord.
How do you know that this is the other two are you are not one of the other?
My lord, they stated they were present there, my lord. Their own statement, my lord.
Who?
Uh,
Two companions beaten him by using then lathi.
yes, my lord.
But one Sensong Rongpi
Sesson Rangpi, written a person with a piece of bamboo stick. That is
okay,
in her-
Sesson Rongpi is piece of bamboo stick. Now, who are the other two?
My lord, other tools has not been mentioned by these
Then-
eyewitnesses. My lord, but their own statement, but I am sorry, my lord, I have not connected statement, I think, my lord. They have stated they were present, my lord.
Where do we get that?
My lord, I have not annexed, my lord. It may be
We'll
recorded.
then take it after vacation.
Yes, sir.
What is the stage?
My
Next
lord,
date is fixed for what?
my lord, for evidence.
For evidence, let us see. Otherwise, if you can satisfy that nobody has named you,
Yes, my
we'll
lord.
think over it, but not like that. Because saying that so and so was present, this so and so was not,
Yes, my
and
lord.
two others are there. If somebody says in FIR you are saying you are there,
My lord, in the meantime, I will file an affidavit along
okay,
bringing that.
do whatever you like. Under prayer of the learned council put a petition and be listed after vacation. Whenever you come for this washing and all, Tharsit more particular, you must annex to show that there is nothing. If we take it, everything to be correct. This is the case.
Hello.
Is that it, Mr. Tar? You have to show us that nobody has taken my name. That your opening argument was that nobody has taken my name. If nobody has taken your name, they cannot
That's
improve their
also
case.
not
It will
taken.
be
Yes, my
discharged.
lord.
But you will have to bring all those evidence.
I will
Yes.
oblige you.
Get us that.
That's the criminal appeal, my lord.
Criminal appeal
Criminal appeal, my lord.
for how many years?
My lord, 6 years, my lord. Lordship may first turn to pay 18 for a 1 part. 1/8, my lord.
1/8.
1/8, my lord. So, I want to show that, my lord. The case was, cognizance was taken under section 342 IP3, that with section 8 of the POCSO. So charges were framed under
The learned trial court. The petitioner was convicted for awarded RI for 3 years and fine of 10,000 for commission and offense under section 354A and a simple imprisonment of 3 years and fine of rupees 10,000 for commission of offense under section 354 IPC, and it is provided that the sentences will run consecutively. Considering the nature of offense and ingredients of section 354 and 354A, this court is of the view that this is not a special circumstance. There is no special circumstance or a special case to direct the sentences to run consecutively. Considering the above, it is provided that till final determination of the connected appeal, the petitioner shall be allowed to go on bail bond of furnishing of rupees 20 to the satisfaction of
additional session just come special just POCSO. My lord,
still just POCSO,
Kamrup,
Kamrup,
Kamrup.
Kamrup. উপরে তো লিখো, though though initially the charges were framed under section 8 of the POCSO Act, however, such the petitioner was acquitted from such charges. Considering the matter in entirety, inside it, I dispose.
Well, the special judge, my lord, after that within bracket POCSO will be.
Special just within bracket POCSO.
I'm deeply of that. Deeply of that.
Yes.
The petitioner channel the ex parte maintenance order. In fact, there has been a delay on 52 days. So Lordship, I has been.
Name, sir.
Yes, ma'am.
How many days delay?
152.
We are condoning the delay. Where is the explanation?
Explanation at case 2, para 2, Lordship.
Para 2. Explanation para 2. The learned counsel for the respondent wife, Mr. S. Ahmed, has not objected for condonation of such delay.
But my
Okay.
record otherwise, my lord.
has vehemently opposed condonation of such delay.
Alright.
However, considering the explanation, allow register the criminal revision petition if not defective and list after vacation.
Much obliged. Obliged.
While listing the criminal revision, the name of Mr. S. Ahmed should be reflected. Yes. Next.
Obliged.
What hearing before vacation? Huh? Get to criminal revision petition.
Yes, my lord. That matter, my lord. Pending disposal of this petition, my lord, the matter was settled.
Matter was
Yeah,
settled.
there was a compromise MOU, my lord,
But
and the
MOU will not do. What I told you that do one thing. Bring the counsel for the respondent wife so that we can close.
but I informed him, my
Huh?
3 occasions, my lord. I inform my lord, my lord, else, yeah,
Huh.
that matter is
His
fixed on
name is
this
shown.
time. Yes, my lord. His name is
Not shown in a court
today.
report. Not shown, no?
Yes.
Lordship,
In the meantime, learned PP may obtain instruction from the sub-register Bongaigaon regarding execution and genuineness of deed of 2025.
yes, Lordship. To that effect, I have got the instruction, Lordship.
Genuine.
Yes, from the deputy register.
Okay.
Lordship, the report is, Lordship, with reference to the subject cited above, I have the honor to inform you that the deed number 2025 dated 3/12/2014 was verified with e-book and found the number 2025 is recorded as memorandum in the name
Are
of
you having the
Resina
phone
Parveen.
number of anybody?
Yes, I can forward.
You just
Yes.
forward it to her.
That is registered in the name of the Resina Parveen. The,
Okay.
yes,
Okay. Just give it to
Yes, yes,
give
sure.
that, we'll quote that in the order.
yes.
Okay, if she comes or if she wants to go to Supreme Court, let her go. The present application is filed assailing a judgment and order dated 11/7/2007 passed by the learned SDGM within bracket as Bongaigaon in complaint case number 366 C/2006, whereby the petitioner was convicted and sentenced under section 490 petitioners or petitioner
Petitioner, Lordship.
One
One
already
petitioner,
in
yes.
appellate court.
One petition.
whatever, petitioner was convicted under section 498 IPC and sentenced to undergo simple imprisonment for a period of 6 months and also to pay a fine of rupees 1,000. Full stop. Full stop. Initially, the learned such conviction was upheld by the learned additional session judge FTC Bongaigaon in criminal appeal number 20 within bracket 3/2007 dated 30/4/2008 upholding such conviction. Full stop. This matter was admitted by this court when stay was there.
Yes, ma'am.
Where is the stay?
2008 matter.
Are you aware that he has
Yes, my lord. He is on previous bail.
previous bill? Where is that order? I think it is the
IA already disposed of.
okay. The petitioner
IA number, my
it
lord.
is submitted. The petitioner is still on bail previously granted by the trial court as well as the appellate court. Full stop. It is submitted by the learned counsel for the petitioner that in the meantime his wife, that is the informant, got married.
Now divorced.
His wife got divorced from himself from the present petitioner and got married to one.
One, my lord, Mazaharul Haq. Lord, this is the.
Okay. Mazaharul Haq. Mazaharul Haq and Mazaharul Haq and both the petitioner and his earlier wife, the earlier victim wife, have amicably settled the dispute among themselves and accordingly entered into an agreement and got it registered before the sub-register Bongaigaon, being deed number 2025 dated 33/12 to not 30 03/12/2014. Pustam. On last none appears for the respondent wife. Full stop. The learned counsel for the petitioner has produced the original of the aforesaid deed of agreement. Deed of agreement. Full stop. As none represented the respondent wife in the proceeding, this court, under its order dated 10/9/2023, requested the additional public prosecutor to obtain instruction from the sub-register Bongaigaon regarding execution and genuineness of the said deed number 2/2025 dated 31/2014. Full stop. And the learned additional public prosecutor has been informed by the sub-register deputy register Bongaigaon regarding the genuineness of the such deed, which is quoted below. You give that?
Yes, I have given.
Musumi, give it to her. She will quote it below. Quoted below. Also peruse the memorandum of understanding. Dated memorandum of understanding dated
3/12/2014.
The relevant portion of which is quoted herein. It pencil mark. You will get it later. The law is by now well settled that Lakshmi Narayan. Accordingly, in view of that, the interim judgment and order that is are set aside and passed. We will get it tomorrow. Lakshmi Narayan.
Obligement.
Dispose of. In view of the order passed in the connected revision petition, interesting thing is your sentence has not been stayed and you are outside anyway. We will not say anything. That IA is still pending and only notice was
Prior to dispose of.
IA in view of the order passed in principle, IA stands. Chalo, both live happily.
Obligement.
Have you married? You able to marry? His petitioner, not you.
Both then.
No.
He also meant
Not you. You are
both. Obligement.
what is this Babulu thing?
Population lordship already heard this matter. This regarding this lordship already
I
decided.
have already crossed my target. 3. I'll have to finish all the work before. Now, what is the case? Tell us.
Lordship will here to take
He's outside or inside?
inside.
Me-
That is why otherwise we are also
That is the interest of the lawyer. Always. Our interest is to justice. Lawyer's interest is the client. Isn't it? translated.
Translated copy I have submitted, Lord. It is.
This is also, this is under what